Thank you again for joining us today. So a little bit about me. I work with the firm of Ambler and Keenan. That firm is located near Mississippi and Colorado Boulevard, and predominantly I do estate planning. So I do wills and trusts and powers of attorney for people. As a part of that practice, it became apparent to me that I work with a lot of different same-sex couples or people in the LGBT community, that I better know what's going on when it comes to civil unions and same-sex marriage. So I have joined into this world here, and I'm glad to try to share that information with you. So my bio is there on the screen. Basically my point in showing you that is that, again, I am an estate planning attorney predominantly. I'll do my best to answer questions that you have. Sometimes I'll have to say to you, you know what, I don't practice in that area, but if you let me know via email, I can sometimes refer you to an attorney who works in a specific area that I don't work in. So feel free to ask away, and if I can't answer it, I'll let you know. Because I am a lawyer, I need to have one of these in here, and that is a legal warning, and that is that I'm only licensed to practice in the state of Colorado. I'm going to talk tonight about some legal things that affect federal law, but keep in mind, if you do have a specific question about another state law, that I may not be able to answer that because I only am licensed in the state of Colorado. So the other thing I want to do is congratulate you on all wanting to spend a beautiful evening. I hear it's kind of warm out, listening to a lawyer talk. I'll do my best not to bore you to tears here, hopefully teach you a few things, and then you can get out and enjoy the evening. So with that, I don't really have any ground rules, because normally this is when I'd say, please turn off your cell phones. But since I can't see you and you can't see me, you can sit and text all you want on your phone. It won't bother me at all. I will get started here, and again, the only rule is if you have a question, feel free to ask it, please. So, civil unions. It means a relationship established by two eligible persons, and that really what eligible means is they have to meet the same criteria that people who want to get married meet, and that is they have to be over a certain age, they can't be related in certain ways, and if they reach that criteria, they can enter into a civil union. And if they do that, what Colorado law said is that they are to then be receiving all of the benefits, protections, and responsibilities of spouses. So whatever spouses get under Colorado law, except for one major area, and I'll get to that, people or parties in a civil union get those same things, whether it's a benefit, a protection, or a responsibility. So spouse is kind of a handy term. If someone walks into a party and they say, hey, this is my spouse, we know what they mean. We know that that means they're married. With civil unions, we don't really have that same fancy, handy terminology. We have people saying, you know, I don't even know how we refer to ourselves now that we're in a civil union. Are we unionized? Are we civilized? And you know, I tend to use the word partner in a civil union when I'm discussing this. The law itself uses the term partner to a civil union, and it also uses the term party to a civil union. So either one will suffice. Again, I tend to use the word partner to a civil union, and it's not quite as short and sweet as saying spouse, but that's the terminology that I'll use tonight when I'm referring to folks who are in a civil union. So if someone wants to get into a civil union, there are two different ways to do that. One is to go down to the county. You can go down to a county in Colorado, any county. You don't have to go to the one you live in, and you can apply and be granted a civil union license. If you do that, you will have all of the Colorado, the state rights that spouses have, except for, again, we'll talk about one, and that's filing a tax return in a certain way. If you do your civil union down at the county, you will have no federal recognition of that relationship. It will only be state recognition. If you choose to do that, how you do that is basically the easiest way to find that is to go to One Colorado's website, and their website is listed on the screen here, one-colorado.org. On their website, they have a kind of a little direction sheet that says here's how much it costs, and here's whether you need witnesses, and here's where you go, and here's what to bring with you. So you need to check on that. Before you go, you may want to look it up so you know that you're bringing the right information and the right fees and all that. The other way to get into a civil union is to go to another state and get married. So a same-sex couple who is married in another state where it's legal, and there are now 19 states where it's legal, can get married in one of those states, and then if you come back here and live in Colorado, you will automatically be in a civil union. And I'm going to get to a little more detail on that. But first, I would say, people sometimes say, well, what state should we go to? We want to get married, but we don't know what state to go to. I don't exactly know, but what I've told people is you'll want to call ahead to that state and find out what the rules are. Some states you have to be in that, you have to be basically in the borders of the state for a certain number of days before they'll issue a license. Some states have certain rules about what you need to bring or how much you need to pay or whether you need witnesses. So again, just check with that state, call them, ask them, what do I need to do? Some of that's probably on the internet, or if not all of it, you can get that information as well. Okay? So again, what I'm talking about here is a legal term that we call reciprocity. Reciprocity says that if you are in an out-of-state same-sex marriage, so you went to one of those 19 states and you got married and you came back and you live here, again, you are automatically in a civil union in Colorado. If you were married before in another state, legally married in another state, before May of last year, then as of May 1st of 2013, all same-sex couples that were married out of state were automatically put into a civil union in Colorado in May of last year. Okay? When this law became effective, you didn't get to opt in or opt out. The law said if you're a same-sex couple that's married in another state, you are in a civil union under Colorado law. Okay? So what the law really says is a civil union, domestic partnership, or what they call substantially similar legal relationship between two people that's legally created in another jurisdiction. And it doesn't say, it says another jurisdiction, so it could be another country or another state that does same-sex marriages. That equals a civil union for Colorado purposes, automatically. So some people say, well, do I need to come back to Colorado and get my Colorado civil union license? The answer is no. If you have an out-of-state marriage license, it automatically is a civil union. If you go to Denver with your Iowa marriage license, the Denver clerk and recorder, it's my understanding, they will take your Iowa marriage license and record it. They don't issue you a new civil union license. What they're doing is making it public record that you have an Iowa marriage. They're recording it like they do a deed, okay, making it public record. In that case, now, some counties, they do a different thing. In some counties, and I'm not sure which ones do which, quite frankly, there's 64 counties, or 63, I haven't checked them all. Some counties, I've heard, will issue a new civil union license. So you walk in with your Iowa marriage license and they issue you a new Colorado civil union license. I'm not really fond of that idea. And the reason is you have an Iowa marriage date, and it is whatever the day is you got married there, okay? And it could have been years ago. And what I don't want is you to go have a new civil union license issued now with a different date. Because now what's the legal date of your relationship? When did this legal relationship start? Was it the Iowa date or the Colorado date? So I'm not saying it's the end of the world, but the paranoid lawyer in me says probably best to not have two different dates of legal recognition. So if you want to get something that shows that Colorado recognizes that, maybe you just go to Denver and you have it recorded, and now you've got it to be public record. You have that Iowa marriage license recorded. So that's basically, again, you don't have to get something, but if you want something, you could get that recorded. The other problem we have, unlike with marriage, other states don't have to recognize your civil union, and I think this is a pretty big issue here, okay? Civil unions are basically only performed, I think there are, last check, 3 states that have civil unions. So you get into this civil union and you think, okay, we're good to go, and then all of a sudden you're vacationing somewhere or you move somewhere else. Most other states don't recognize that civil union in any way, shape, or form, okay? They consider you legal strangers, so that's something to keep a close eye on. There are 2 websites I list here on this slide, HRC's website and Freedom to Marry. They basically have pretty up-to-date stuff that says, here are the states that have civil unions. Here are the states that honor other state civil unions. Here are the states that have marriage, all of that. So you can take a look at those websites, and usually they'll give you pretty good information about how to make sure that the state you're going to or the state you're in honors that relationship or not, okay? The other thing to keep in mind is if you want to get into a civil union, you can't force any religious institution or any Indian tribe to verify or certify, excuse me, your civil union, okay? So you can't walk into the Catholic Church and say, priest, I want you to be the one that certifies my civil union. No go, okay? So you cannot force them to do that. I want to cover a little bit about civil unions and children. Some of you may not have children. You may know people that do. This is just, I think, helpful information, and I think good for all of us in the community to know about where things stand with regard to the people in the community who do have kids. What are their legal options? Okay, so I'm going to cover that. I won't. I'll just hit kind of the highlights. So the first thing is, in 2007, which is now quite a while back, okay, Colorado was one of the early on states to recognize what we call second parent adoption. And what second parent adoption is basically a person who's over 21 can adopt someone else's child even if they're not married to that someone else. So if there is a child who has a sole legal parent, so let's say a woman went out and she got a sperm donor and she was artificially inseminated and she gave birth to a child, okay? At that point, she's a sole legal parent. If she wants someone else to adopt her child, that person, and they want to adopt that child, that person can do that. They don't need to be in a civil union with the other mom. They don't need to be married to the other mom. They simply need to all agree, or both agree, that they want her to adopt. The issue with the second parent adoption, and again, I still do these, for folks who come in, same-sex couple comes in, there's a sole legal parent of a child, and the other one wants to adopt, and they're like, we don't want to be in a civil union. We're not in a civil union, and we don't want to be. Well, that's fine. We can do a second parent adoption. One of the steps of a second parent adoption is that they do have to have a home study done. So they have to hire a home study company or person who comes out and does a home visit and talks to references and writes up an entire home study, okay? For second parent adoptions, home study is required. The other thing that has been brought up recently is the Department of Human Services is now also requiring the adopting parent to do parenting training. That was fairly new. That came up 6 years into the bill being effective. I'm not sure exactly why, but they realized, oh, we can order them to do these, so let's make them do parenting classes. So unfortunately, if you want to do a second parent adoption, they can force you as the adopting parent to do parenting classes, unless you got a judge to say that you didn't need to do that. So that is one potential possibility. So now, what if a couple comes in and they are in a civil union? In that case, they can now do what's called a step-parent adoption instead of a second-parent adoption. So a step-parent adoption is different. The biggest difference is you don't have to do a home study. So you don't have to hire an agency to come and send somebody out and to talk to references and write up a whole report. The adopting parent, and this is true with any step-parent adoption, so this has been going on for married couples all along, and this is now the same. These are now the same rules for partners in a civil union. You want to adopt your partner's child and you're in a civil union, you have to get an FBI and CBI background. You actually also get what's called a TRAILS, which is a child abuse registry background. And then you go to a hearing, you file paperwork with the court, and you go to a hearing, and the judge, barring any problems, will order the adoption. Okay? So no home study, but still a CBI, FBI report, and a hearing are required. It says on this slide, it's been interesting, out-of-state birth certificate. So sometimes, you know, the kid's here, but they were born in another state. And so we get this court order, and the judge says, okay, you're going to be the parent, and we're going to send this off to vital statistics. The problem can become that out-of-state clerks and recorders or out-of-state vital statistics offices sometimes look at that court order and say, what? You want me to put two moms on the birth certificate? I'm down here in Florida. I don't know how to do that. I'm not going to do that. All sorts of things I've heard. Basically, the bottom line is they have to honor that court order. I know that there is currently a dispute going on in Oklahoma around that, and ultimately I think the state will lose that. But sometimes there's some educating to do. Sometimes there's some arguing to do to get the second mom or dad put on the birth certificate. Until we have a better way, I think that's just going to be a possibility, okay? Now, there is a statute under Colorado law that if the other state ultimately flat out refuses to put both parents, both same-sex parents, on the birth certificate, Colorado Vital Statistics must issue a Colorado birth certificate for that kid with both moms on it or both dads on it. So there is a safety net there that Vital Statistics here could issue a birth certificate even though the kid wasn't born here. Kind of an interesting concept. So we'll see where that one goes. Again, I don't know that that problem is just going to go away. The other thing about kids is this. A person who has a partner in a civil union cannot adopt someone without their partners adopting with them. So I always joke, you can't go to work, come home from work one day and have your partner say, hey, look, honey, I adopted a kid while you were at work. That is not possible. If you are in a civil union, you have to petition and adopt together if one of you seeks to do that, okay? At least adopting a child. Puppies and kittens, fair game, okay? But a child, they have to do that with you. And the final thing on adoption here is there is no exception for a religiously affiliated agency to opt out of assisting you. If you are a same-sex couple, if you walk into an agency, an adoption agency, they cannot refuse to work with you simply because you are a same-sex couple, okay? Now, most people aren't going to walk into an agency that they think is not going to treat them nicely or fairly, but by law, they're not allowed to treat you any differently than any other couple, okay? Okay, and the final thing on children. What the law really said, the civil union law said, look, if one of you conceives a child during the time that you are in a civil union, then we are going to presume that both of you are that child's parents. It's just like we do with marriage. If you think about it, when a wife gives birth to a child, we presume her husband is the parent, is the father, okay? Nobody blood tests him at the hospital. She simply puts his name on the birth certificate, and we presume because they're married, he's the father. Now, it's what we call in the law a rebuttable presumption. That is, someone else, some other guy could come running in and say, nope, that's not his kid, that's my kid. And he can rebut that presumption that the father is, that the spouse is the father. So the same is true with civil union partners. And so the law said you had to be in the civil union at the time the child is conceived, and then you're presumed to be parents. Well, what actually happened was shortly after the civil union law passed, Vital Statistics began issuing birth certificates with, for instance, two moms' names on them. And so there on the news was a couple with a child saying, look, we're both on this birth certificate. And I promptly called Vital Statistics because the way I read the law, and I wasn't trying to cause trouble, I'm trying to figure out what do I need to tell people? What are their options? So I called Vital Statistics and said, look, the law says this kid had to be conceived at the time the partners were in a civil union. And this is 4 weeks after the civil union bill passed, so I know this kid was not conceived during the civil union. And Vital Statistics finally came back after speaking with their attorneys and said, well, we're not going to worry about what that law said. We're just going to issue these birth certificates because we're not in the business of trying to figure out when people conceive their child. So that concerns me a bit, okay? Again, my job as a lawyer is to think of the worst case scenario. So if the kid wasn't conceived during the civil union, do we have a birth certificate that could be challenged? Do we have the potential here that if this couple splits up, the biological parent says, you have no legal rights to this child, this birth certificate was not issued legally, you're not a parent, and get out? Or do we have the parent who adopted saying, or not adopted, the parent who put their name on the birth certificate saying, oh, I'm not really a parent, this wasn't issued legally, the kid was not conceived during our civil union, and I'm not paying any child support. Now, I'm sure a judge will have to sort this out at some point because I'm sure this will happen. But what I've said here is, should you get a court order anyway? My opinion is yes, that relying on a presumption of law, first of all, that, again, only 3 states even honor civil unions. So is that enough? Is that enough to protect your family? I think that there's some risk there. Again, I've had clients say, we're willing to take that risk. That's absolutely fine. People can ignore my advice if they wish to. That's fine. So just something to think about. Again, I'm glad to talk to folks about these things on their own personal situation if people have questions, but hopefully that gives you some idea of where we're going with the civil unions and the kids issues. So how do you recognize your relationship? How do you get your relationship recognized legally? There are a number of different options, and they all still exist, okay? The first one is you can register a domestic partnership. So a lot of couples have registered their domestic partnerships. You can go to Denver, Aspen, Boulder, and you can go in and say, we want to register our domestic partnership. When you do that, what happens on a legal perspective is really nothing. You get no legal rights to anything. It has no recognition for any of the rights that spouses get or that partners in a civil union get. So why would you do it? Well, some people have done it as proof that they're in a domestic partnership. So if your employer says, hey, we'll provide domestic partner benefits to our employees' partners, they'll say, here are different ways that you can show us you're in a domestic partnership. One may be register it with the city of Denver or with anywhere, okay? Register your domestic partnership, and then we'll have proof and we'll give you benefits. So that is generally why people will register a domestic partnership. It is completely different than a civil union. It is not the same thing. And again, it does not give any sort of legal rights attached to it. The next step, a few years after that, well, that's been around quite a while. The next thing that came along was what's called a designated beneficiary agreement. So before we had civil unions and before we, well, basically what happened is the legislature was saying, okay, we'd like to give some of these rights that spouses get to same-sex couples. How can we go about doing this? So the idea that came about was called a designated beneficiary agreement. It's unique to Colorado. We're pretty much the only state that has it. Hawaii had something similar. It is a contract, and what it is a two-page contract, and if you Google this, you'll find it, the designated beneficiary agreement in Colorado. It's a form, and it's a pretty powerful form, so I caution people to probably not just fill it out without talking to an attorney, but you know, I'm an attorney, so of course I say that, but it really holds a lot of power. And what that form does is it gives this couple that signs it, or these people, they don't even have to be a couple actually, 16 of the rights that married people get, they can give each other, okay? And I'm not going to get into great detail about it, but I will say a couple things about it. One is the people signing it have to be two competent adults. They both must be unmarried, not just to each other, meaning they're not just unmarried to each other, they're not married to anybody, okay? And they don't even have to be a couple. It could be an elderly father and his daughter who is not married, okay? He can't be married, she can't be married, but they want to give each other these rights. They can do that, okay? You also can't have more than one of these designated beneficiary agreements. So I can't give 14 of the rights to one person and then sign another one and give 2 rights to another person. You could only have one at a time, okay? No one can force me to sign it. We both have to sign it. We have to have a notary notarize our signatures. There's a disclaimer on the form, and you have to have the disclaimer on it. It's not valid if somebody types it up or prints it out and doesn't have the disclaimer on it. And the disclaimer basically says, don't sign this if you don't know what you're doing, okay? And then it has to get recorded. If you sign this with your partner, and I've had people come in and say, well, we signed that, but we just put it in the drawer or whatever. No good, okay? It's absolutely useless paper unless it's been recorded with the clerk and recorder in the county where you reside. If you reside in different counties, pick one, okay? But it must be recorded. So 14 of the rights out of the 16 are rights that are basically covered when I do someone's estate plan. So I'm not getting into all those, as in a medical power of attorney, a financial power of attorney, a will, all of that stuff. So most of them are covered, but I still do these for clients who come in, they're partners, and they're not in a civil union. And there's these 2 reasons on the screen are why I do a designated beneficiary agreement for my clients if they're not in a civil union. One, they need to have the right to have standing to seek workers' comp benefits. If their partner is killed at work, so let me do it this way. If you were killed at work, your spouse, if you had one, could seek workers' comp benefits. Your partner in a civil union, if you had one, could seek workers' comp benefits. But if you are not in a civil union, what do you do? Well, if you have this designated beneficiary agreement all filled out, right, and recorded, and your partner is killed at work, you can seek workers' comp benefits, just like a spouse or partner in a civil union can. The other one is the right to have standing to sue for wrongful death. I hate to think that you'd need any of these, but if somebody harmed your partner and you're not in a civil union, you don't have what's called standing or the ability to sue for wrongful death. If you sign this designated beneficiary agreement, you can have that right. Okay? So those are things, again, I hope you never need, but important to know about. So a civil union, what other rights do you get? So the 16 rights on the designated beneficiary agreement are automatically granted when you're in a civil union. Okay? Then it also gives a bunch of other rights, and I'm going to cover some of those as to what those rights are that the state of Colorado gives people who are in a civil union. Basically, the way the law is written is all of the rights, benefits, protections, duties, responsibilities that spouses get under marriage law are also granted to people who are in a civil union. Okay? So whether it's a rule or a statute or a common law or anything, anywhere a spouse gets something, a partner in a civil union is supposed to get the same thing. And originally, on May 1st of 2013, what the civil union law said was you get all those rights, but you don't have the right to file your taxes jointly, your Colorado taxes, okay? And that is still true. If you got into the civil union down at the county, you didn't get into the civil union via a marriage somewhere else, you still file your tax returns as single individuals, okay? So if you went down to the county and got into your civil union, you'll still file your federal and state returns as single individuals. Now, I'm going to get to the issue of if you got married in another state, you're now going to file a married return, and you'll need to file your Colorado return the same way. Okay, that was a new law that passed this year to make it work. Otherwise, we had a kind of a disconnect in the law. So I'll come back around to that issue. Okay. So in the law, a party to a civil union is included anywhere in the law where we see the word dependent, family, heir, immediate family, next of kin, spouse. Anytime you see those terms, or a lawyer sees those terms in the law, they're going to include partner in a civil union included in that. Okay? So what are these rights? And I often joke, I'm like, well, I don't know that married people even know they have most of these rights because they never took a class before they got married and said, hey, what are those rights I'm going to have? Am I going to have the right to sue for emotional distress? Well, actually, yes. The answer is yes. So what are some of these rights that the state gives to spouses and now gives to partners in a civil union? And when I say the right to sue for emotional distress, I don't mean sue your partner. I mean if someone harms your partner, one of the causes of action you can bring is that that harm has caused you emotional distress. And again, I don't practice in that area of the law, so you'd have to talk to somebody about what meets the criteria of emotional distress and so on. But basically, that is one of the things you may be able to sue for if somebody harmed your partner. The other, if somebody harmed your partner, you could sue for what's called loss of consortium, loss of sexual relations, if that had occurred. We have what's called a dram shop law. That's an interesting one. You could sue an owner of a bar or restaurant if they served an intoxicated person too many drinks and that person injured or killed your partner. Now you have the right to sue under the dram shop law, sue the bar or restaurant. Again, if you're legal strangers, not in a civil union, you don't have these rights. Hopefully you never need them. The other thing that came along is the right to designate your partner in a civil union as a beneficiary if you're a state public employee. So you could name them as the beneficiary under the retirement system. If you're a local firefighter or police person, okay, survivor benefits can pass if you're to your partner in a civil union now. That's a pretty big deal, okay? So those things are now available if you are in a civil union. The right to apply for compensation as a relative of a victim, okay? So if someone harms your partner and you're in a civil union, you have certain rights, the right to receive restitution, the right to be kept informed of what's going on in the criminal justice process. So those things are very helpful if those issues were to ever come up. Insurance. So most of this law came into effect on May 1st of 2013. The insurance portion of the bill did not become effective until January 1st of 2014, okay? And what really happened was, I can kind of shorten it to say, any insurance that treats spouses in a certain way must now treat partners in a civil union the exact same way, okay? So, for instance, the middle bullet here, insurance coverage provided by a health coverage plan. So basically, if a health coverage plan says a spouse is a dependent, a health coverage plan must now say a partner in a civil union is considered a dependent. Okay? So if your employer covers employee spouses one way under their insurance plan, they must now cover employees' partners in a civil union that same way. Okay? They cannot pick and choose. Now, I've had people say to me, well, my employer said, well, we're really located in Oklahoma, so we don't have to follow that. Okay? If that happens, I can certainly get you to someone who can advise you on that type of legal issue. If you need that information, you can always email me and say, I need somebody to help me because my HR is not cooperating. It's beyond my expertise, but I know there are folks who could help you. Bottom line, need to be treating partners in a civil union the exact way they are treating spouses. So other insurance policies also, like home ownership or car, those types of things. I know I got a notice from my insurance company, my property and casualty insurance, that said, you know, we're going to, if you're in a civil union, you're treated the exact same way as a spouse. Okay? Now, one of the things that you have to be aware of is if you are not married, you are either not in a civil union or in a civil union because you went down to the county, but you're not married in another state, okay? If your employer comes and says, okay, we're going to put your partner, even though you're not in a civil union, we're going to put, excuse me, you could even be in a civil union, but if you're not married somewhere else, so let me start over. If you're not married in another state and your employer comes and says, we're going to put your partner on our health insurance, and as the employer, we're going to pay for that. So the $400 a year that it costs for your partner, a month that it costs for your partner to get health insurance, we're going to pay it. The thing you need to be aware of is as the employee, you're going to pay income taxes on that $400 a month, okay? So only if the employer is paying it, it's going to be considered income to you. If you're paying it, it's not a problem. If the employer is paying it and you're not married in another state, then you need to just be aware of that. And that I know I've had clients call and say, can they do this? And it's my employer, and they're, you know, it's not your employer. It's because the IRS does not recognize civil unions or partners who aren't even in a civil union. They don't recognize that. And so that's why it is considered income to you, and you're going to pay taxes on it. So there are other things. Sometimes people have said to me, well, I'm in a civil union now, so I don't need an estate plan, okay? I would say I would disagree with that, and that is not a true comment. I have been doing this for a long time, and I will tell you that I do estate plans for married couples. I have for my entire career, as well as unmarried couples, as well as partners in a civil union. Being in a civil union doesn't give you all of the rights that you often think it does. And I've actually was just reading an article that misinterpreted what the civil union actually does with regard to your health care decisions. So let me say this. You do still need what we call a health care or medical power of attorney. What Colorado law says is if you don't have a medical power of attorney appointing someone to make your medical decisions and you get hurt, and there everyone stands and they're like, well, she can't make her own decisions, so who's going to make them? Colorado law does not say that your partner in a civil union gets to make those decisions. And Colorado law does not say your spouse, if you're married, gets to make those decisions. What it says is all interested parties in your life are supposed to get together and pick a decision maker. It's called a proxy decision maker. So everybody in your world is supposed to get together and pick a decision maker. Now, if you're in a civil union, one of those interested parties that gets to help pick the decision maker is your partner, if you're in a civil union. But they are not the end-all, be-all decision maker. So you really need a power of attorney that says, this is the person, this is the guy I want to make my medical decisions. And if he can't do it, I suggest that your power of attorney have some backups, okay? It would say if he can't do it, it's this one. If this one can't do it, it's this one. It should also specify that you have the right to visit, the agent that you've appointed, your partner, or any of the backups for that matter, can visit you in any healthcare facility. People often think, okay, well, I'm in a civil union, so now I'll be able to visit my partner in a hospital. Well, by law, that is correct. But I can tell you that everyone standing in that hospital has no idea what the law is, and whether, or that they may not even know we have civil unions, and they may not even know what a civil union means. So, and my other probably bigger concern is your civil union isn't honored in 47 states or something like that. So you need a healthcare power of attorney, and it needs to say this person can visit me in any healthcare facility. Okay, I think I've beat that one to tears there. Okay, the second thing, HIPAA. HIPAA is a Medical Privacy Act, and it is a federal law, and it says healthcare providers, you are not to share any patient's health information with anyone else. And so if you're hurt and your partner walks in, whether you're in a civil union or not, they're going to hear, they may very well hear, we can't talk to you because of HIPAA. Being in a civil union has no effect on HIPAA, okay? It is not legally okay for that healthcare provider to share medical information with anybody, even a spouse. Now, societally, sometimes healthcare providers start spewing out information to spouses. Technically, they're violating HIPAA. As a society, that often happens. But as a society, I don't know that we're quite to the point where they're going to just start spewing information to partners in a civil union and be willing to violate HIPAA, okay? So, again, what I have clients sign is a HIPAA release, and it basically says, these people, my partner, can get my medical records and information if they need them, okay? So I think that's an important one. Living wills are also important. I know these are pleasant topics for a beautiful evening. You're sitting there. But important things to cover. A living will is basically about making your own decision about whether or how long you'd want to stay on life support if you were terminal. And if you have a living will from before 2010, it may not cover how long do I want to stay on life support, not only if I'm terminal, but what if I'm in a persistent vegetative state. So Colorado passed a new living will law about 4 years ago in 2010 that said we should probably cover that persistent vegetative state issue. So you need to check your living will if you have one, and if you don't have one, you need one that basically says these are my wishes. I don't want anyone to be arguing with partner and parents and siblings about when does the plug get pulled if you're terminal. You get to make that decision on your own, okay? Even more comforting to talk about this evening is what about your last remains? This is a big one, and this is a problem that I've seen throughout my entire career, and that is who gets to decide if you're buried or cremated when you die. Now, Colorado law does, well, let me say this. You can sign a statement, and that's what I do. One thing I do for all my clients is I want to be buried or I want to be cremated. My partner is in charge of this, okay? No questions asked. It's then legally binding. There is a priority that the statute says, okay, if you die and you haven't said in a written statement whether you want to be buried or cremated, here's who gets to decide. The top of the list is whoever you nominated in your will to be your personal representative, which is what we used to call an executor, okay? That person in your will who's named to be in charge has the first priority above your partner even if you're in a civil union, to decide whether you're buried or cremated. Now, second in line would be your partner, so that is helpful. The civil union statute did help us there. In my mind, it's still a safer thing to have a statement that says, I want to be buried, I want to be cremated, and this is who's in charge. So that's why I do a last remains declaration for all my clients. Next is what's called a durable general power of attorney. Some call it a financial or a property power of attorney. So sometimes people think, well, again, if I'm in a civil union, I have the right to handle my partner's finances. That is not true. It's not true for spouses either, actually. When we get same-sex marriage here in Colorado, people will still need a durable general power of attorney. If you're hurt and you don't have a power of attorney appointing somebody to handle your finances, then somebody's going to have to go to court and get appointed as what's called your conservator. Now, a conservator is a court-appointed person, and luckily, at least if you're in a civil union, the court is told to appoint your partner in the civil union as the top priority, okay? So they'd at least have an out. But rather than have to go to court and get appointed and do any of that stuff with a judge, you could just sign a durable general power of attorney that says, I appoint my partner to make these decisions, okay? A durable, the word durable simply means that it's a power of attorney that is effective and remains effective even if you are incapacitated. So if you are incapacitated, the power of attorney is still valid. And most people think, duh, that's what I want. But you have to be careful, because I've seen people get powers of attorney off the internet or whatever, and I don't know who wrote it, some 10-year-old in their basement maybe, but it's not effective upon incapacity, or it doesn't remain effective upon incapacity. So that's something to really be aware of. A power of attorney should name backups, and if the power of attorney is appointing someone who is not your spouse, is not a partner in a civil union, is not your descendant, your kids, or is not your ancestor, your parents, you have to be careful. So really the bottom line is, a newer power of attorney is going to take this law into consideration that limits people's powers. Certain people have limited powers under Colorado law. When I draft a power of attorney, I can draft around that problem. I can make sure that we're not having limits put on their actions. Okay? So that's a durable general power of attorney. So back to civil unions and what they do offer, because those were things, again, that even if you're in a civil union, you probably need those things. Okay? The other thing you get, if you get the right to be legally recognized, you get the right to legally split that relationship, but you can't just do it on your own. So if you are in a civil union and you split up, you need to get a divorce. Okay? I had a call last week from someone. They were splitting up. They had absolutely no idea that they would have to now get a divorce. And there's no like, okay, we just agree to be divorced. No, you have to file the appropriate paperwork. So just like with married couples, when they split up, someone has to file for a dissolution, okay? Or both people can. I'm not saying it has to be World War III. I'm just saying you have to go through the process, the legal process. One of you could be forced by a judge to pay maintenance, okay? If you are the higher wage earner, and now you're turning to look to your partner if you are the higher wage earner and you split up, then you could be forced to pay maintenance, what we used to call alimony. And there is a new maintenance law that uses a formula to determine what that maintenance will be. And if the judges don't have to use it, but if they do use it, it generally means the higher wage earner is going to be ordered to pay some sort of maintenance or alimony to the other partner. And a judge, if you can't decide how to split your property while you're getting divorced, a judge will make that determination. And it's supposed to be what's called equitable. And generally when you're done with a divorce or a dissolution, nobody feels it was very equitable. But that's the way it's supposed to be, okay? So just keep in mind, you get into a civil union, you split up, you don't get to just like pack up the U-Haul and drive away. You are married, you're treated as if you were married, which means you need to get divorced, okay? So one of the questions that's come up, though, is will a Colorado divorce dissolve a marriage from another state? Okay? So you went to Iowa, you got married. You came back here. You decided to split. You dissolve your civil union. Does that dissolve your marriage in Iowa? I think my answer here has to be we don't know. Okay? Now I know that the divorce attorneys who are doing same-sex or dissolutions of civil unions here are writing into the decree, this dissolves this relationship in every state, okay? Now, whether that works or not remains to be seen. Can a dissolution of a civil union dissolve a marriage in another state? We don't know. And I think an interesting way to look at it is Iowa doesn't even recognize civil unions. So how would dissolving a civil union do anything to your marriage in Iowa? I think it's something that's going to have to get sorted out. And unfortunately, I don't think there's any clear answer at this point. So the other thing that you need to know is if you get into a civil union and you die, your partner in that civil union has a right to a part of your estate when you die. So what they get, the first thing they get is what's called a family allowance and an exempt property allowance. And this has been true for spouses for a long, long time. If a partner in a civil union dies, this is the number this year, $64,000 of their estate goes to their partner before anyone, before credit cards get paid, before anything gets paid, they get the first $64,000. The idea is that we don't want to impoverish the surviving partner, okay? And again, this has been happening for spouses for years. Spouses have had a right to come in and say, I get the first 64 grand. Well, the number is indexed up over the years, but I get that first 64 grand and I don't care that he owes you $100,000 in credit card bills, okay? So the other thing is you can't disinherit your partner if you're in a civil union. So if someone calls me up and says, I want to do a will, but I want to leave everything to my niece, I'm in a civil union, but I want to leave everything to my niece, not my partner. I have to ask them, well, do you have an agreement to that effect with your partner? And usually the answer is no. Well, what I have to tell them next is that when you die, your partner, whether your will leaves everything to your niece or not, can come in and ask for his share. He can say, my partner, I was in a civil union with that partner, and we had been together for 10 years in that civil union, and at that point, he would have a right to half of your estate. So what the number is 5%. He has a right to 5% of your estate for every year you're in a civil union, up to 10 years. So at your death, he can come in and say, we were in a civil union for 5 years. I get 25%. I don't care that his will says give it all to his niece. Okay? So they have a right to that. Now, what if you said, well, I don't care. I don't want part of my partner's estate when he dies. I don't care if he leaves it all to his niece. Well, then you can sign what's called a marital agreement. And I know this isn't a marriage, but it's basically a prenup without the nup part, okay? It is, you may modify the terms of your civil union in the same way that spouses can, by signing a marital agreement, by signing an agreement that says, I won't come after any of your money when you die. Or if we split up, I agree that what's mine is mine and what's yours is yours, okay? So you can do some sort of contractual agreement. You definitely want to talk to a lawyer and have that drawn up correctly, because those are pretty easy to blow out of the water if they're not done correctly. So if you need referrals, I can give you those, but marital agreements are doable, okay? So I'm going to finish up here with talk about DOMA, and then let you out into this beautiful night. Did the Supreme Court's ruling on DOMA affect my civil union? Well, if you went down to the county and got into a civil union, then the answer is no. Civil unions are not marriages. So the Supreme Court's ruling on the Defense of Marriage Act and saying that part of it was unconstitutional had no effect on civil unions under Colorado law, okay? Now, what they did do is they said, if you're married in another state, then this DOMA ruling, this Defense of Marriage Act ruling, did have an effect. And again, I mentioned there are 19 states in the District of Columbia that allow same-sex marriage. I don't know, that could have changed in the last hour. It's changed quite often in the last few days. Other states, like Colorado, have statutes, and Colorado has a constitutional amendment that says marriage is one man and one woman. And that's, you know, there are battles in court. There's talk about putting that on the ballot in the coming years, and that will probably be challenged in one way or another. But currently, as we stand, Colorado has a constitutional amendment that does not recognize your marriage, okay? However, even though that's the case, some federal agencies will still recognize your marriage. So I go to a state where same-sex marriage is legal, I get married, I come back to Colorado. Remember, it's an automatic civil union for state law purposes. Whether you want that or not, you are in a civil union. What federal rights do you get? Each federal agency deals with this differently, and this is where it gets kind of strange. Each agency decided, or is in the process of deciding, some of them, whether they're going to honor same-sex marriages or not, and how. So, for instance, immigration. Immigration uses one of the ways, and that is called a place of celebration. What that means is, as long as the marriage was validly entered into under the law of the state where you got married. So you went to Iowa, which is one of the states where it's legal to get married, and you got married, okay? Even though you live in a state that doesn't recognize that marriage, i.e. Colorado, then the immigration will still honor that marriage, okay? So as long as you celebrated or got married in a place where it was legal, immigration will honor your marriage no matter what state you live in, okay? Social Security is different. Social Security is kind of a, well, the bottom line is right now Social Security says unless you live in a state that recognizes your marriage, we're not going to. So if you live in Colorado that does not recognize your marriage, Social Security is saying we're not treating you like spouses. However, as I've said on this slide here, there are some national organizations, and probably some local ones too, the NCLR, ACLU, NCLR, ACLU, or places like that have said, we think that being a partner in a civil union will qualify these two people as spouses under under Social Security law. So I think it's going to be a test that's going to have to happen. It has not happened yet. So there is some argument that by being in a civil union, you would qualify for Social Security just like a spouse. I tell people we don't know that yet, and I've heard people from Social Security Administration saying no, that is not the case, but I think there is a legal argument that may work, and there are certainly organizations who are willing to take that fight on. So what the bottom line is Social Security's website says, even if you think you might not qualify because your state doesn't recognize same-sex marriage, apply anyway. And it kind of says, we're working on it. We're working on it. If you look on the Social Security website, it says it about 1 million times. I don't know what they're still working on, but they have not yet changed all their policies. So Social Security is one that's kind of up in the air. Federal taxes, the IRS came forward and they said, just like immigration, we're going to use state of celebration. So now you need to know, if you're married in another state where it was legal, you will now be considered married for all IRS purposes. Okay, you need to file your returns as married. There's married separate and married joint. You talk to your tax advisor about which one to file, and you will need to file that way. Okay, even if you live in a state like Colorado that doesn't recognize it. One of the things that some people have done is they've been married for the past 5 years in another state, and what the IRS or some tax advisors are doing actually is amending tax returns. They're going back for 3 years and saying, we want to amend our returns. You'd want to obviously have a tax person run the numbers. One of the times when that might make sense is if you've been paying income taxes on that health insurance benefit. Okay, again, if your employer was paying for your partner's health insurance and you've been paying income taxes on it, it might get you some money back if you file amended returns. Again, I'm not a tax advisor, so I would have you talk to them, and if you need a referral, I can give you that too. Okay. So benefits of being federal spouses, transferring property back and forth when you get divorced are not gifts between each other. Okay. Maintenance, if you get ordered to pay maintenance because you're the higher wage earner, you can deduct it on your taxes. Estate taxes aren't due when the first spouse dies. You can do lifetime gifting between your partner, between you and your spouse without having to file gift tax returns or having to worry about any gift taxes being incurred. And again, I mentioned the cost of the insurance, if your employer is paying it, is not going to be taxable to the employee spouse. Okay? And there are lots of different planning things for financial advisors that they can talk to you about. I'm not a financial advisor either, but again, funding a spousal IRA. If you're a non-working spouse, can your spouse fund an IRA for you? In some cases, yes. If your spouse dies, you can roll their 401k into your own IRA and not have to start taking it out and paying income taxes on it. So lots of different rules around this. If you have a financial advisor, I would talk to them about what the new planning opportunities are. If you don't have one, let me know. I can get you some names. You can always email me. So things that we didn't have on our radar before, things we had no idea because we couldn't do them. We just probably didn't pay a whole lot of attention to those things. But now it's possible if you're married in another state. Military will do the same thing. They will consider you married even if you live in a state that doesn't recognize your marriage. So if you're in the military and you get married to a same-sex spouse, they'll consider you married for all purposes no matter where you live. Okay? And there's a few things listed there that military folks will get. The problem or the irony here is that the military won't honor any marriage, but the Veterans Administration will not. The VA says you have to live in a state that recognizes your marriage. Okay? One of the problems is the VA defines a spouse as a person of the opposite sex who is a wife or a husband. Okay? And so that was done years ago, and that's going to need to change. But as it stands, if you are a veteran, my understanding is that your spouse does not get treated like a spouse if you live in Colorado. Okay? You would need to live in one of those 19 states where your marriage is legally recognized by the state, and then the VA would recognize it. So that one, again, there's court cases and all sorts of things going on that may change that, hopefully sooner rather than later. The Justice Department, I hope you don't need these things, okay, but the Justice Department is the latest one that came forward and said, we're going to use the place of celebration, meaning as long as you got married somewhere it was legal, we're going to consider you married even though you live in Colorado. That means you can't be forced to testify against your spouse in federal court. So if she tells you about the bank robbery, you cannot be forced to testify in federal court about that, okay? If the court case goes very poorly and she ends up in federal prison, you will be able to visit her like a spouse, okay? So spouses, same-sex spouses, will be treated the same as opposite-sex spouses for all Justice Department activity, okay? And one of those is also payment for spousal compensation. So when something like September 11 happens, the federal government sometimes compensates spouses of the people who were harmed. In that case now, same-sex spouses will be treated the same as opposite-sex spouses, okay? So hopefully we don't ever have to do that again, but if it's there, they will treat same-sex spouses the exact same now. It does not matter what state they live in, okay? And the last one is the Family Medical Leave Act. If you are needing time off to take care of a sick spouse, or let me say it this way, the federal Family Medical Leave Act will not apply to same-sex spouses in Colorado yet, okay? You need to live in a state that recognizes your marriage, or the FMLA does not, okay? There is a Colorado state FMLA that says partners in a civil union can get time off to take care of their partner if they're very ill. There are all sorts of rules. It's unpaid time. There's a limit on how long you can take. But know that there is a state FMLA that you could check into if that ever came up and you needed to deal with that. So again, the firm that I work for is Ambler and Keenan. I'm always glad to chat with folks. I do a free 1-hour estate planning consultation. So if you finish with this and you think, you know, we should talk to Erica about wills and powers of attorney, you simply call my office during the week and they will set you up for a free 1-hour initial consultation where we can talk about your situation. I can talk about what you're trying to accomplish and how it works. I do a flat fee charge for that kind of stuff. So you basically just come in and listen and get educated, and I'll tell you what your options are and what they would cost, okay? So I'm going to try to take a couple of questions here. We were married in D.C. in May and also got a civil union in Colorado. Do we need to make any changes to our trust? You know, generally what I'm telling people is if you already have a trust and powers of attorney, you don't need to change them simply because you got into a civil union or you got married. There is a statement in your trust, most likely, that says, we are not married, or this person is my partner. That statement is really just the status of your relationship at the time you signed the document. What I'm saying is the fact that your legal status as partners has changed does not mean you need to change the document. Now, if you're coming to me, I try to do a 3-year review with all my clients, and if you haven't done it, you need to come and do it. And you're changing your trust or your will for some other reason, then, hey, I'd say at that point we would change that section of the will or trust. But if you're just thinking, oh, you know, there's nothing else we need to change, and again, I'm glad to do a 3-year review for free and let you know that. But if there's nothing else that needs changing, you probably don't need to mess necessarily with those just because now you're married. And congratulations, by the way. If the federal government rules that state bans on same-sex marriage are unconstitutional, what will that mean for Colorado? Will a vote still be required to remove the state ban? No. If the U.S., the federal government, so I'm assuming when you say the federal government, I shouldn't assume anything. If you're saying the U.S. Supreme Court rules that it is unconstitutional for a state to ban same-sex marriage, there will not need to be any further action taken in Colorado. So if the U.S. Supreme Court strikes down the rest of DOMA, basically, then we're done. Same-sex marriage will be legal in every state, no matter what the state law says. Because what they would be doing is saying, it's unconstitutional for you, Colorado, to ban these people from getting married. Okay? Under the U.S. Constitution, it is not okay. So that would give us a result that would be quite nice. I know there are cases going forward. I think that will happen hopefully sooner rather than later. I don't see any others coming through. Again, I appreciate your time and attention. If you know anybody that would be interested in this information, feel free to pass along the fact that probably within a week we'll have this on our website, maybe sooner. If people want to watch, it'll be on our YouTube page. If you, again, want a free initial consultation or your 3-year review, give us a buzz, and we're glad to help you. So thank you again for your time.